Hi, so in this video, our group Optimum Pride is going to present about the industrial relation systems of United Kingdom. So this is our team. My name is Chin Wei Xiang. We have Angyot Lin, Jesnita, Ido Zuen, and Olivia.
I will be giving a brief overview of the United Kingdom, focusing on its governance, economy, demographics, and why it's relevant benchmark for Malaysia. First, the government system and economic setting. The UK operates under a constitutional monarchy with a parliamentary democracy. This means the monarch serves a ceremonial role while the Prime Minister holds executive power. It comprises four nations: England, Scotland, Wales, and Northern Ireland. The UK has a highly developed economy, historically built on manufacturing but now dominated by the services sector. As a global financial hub, London plays a major role in international business and economics. Second, the population size and demographics. The UK's population is approximately 67 million, with around 83% living in urban areas. Major cities include London, Birmingham, Manchester, Glasgow, and Leeds. The UK is known for its ethnic diversity, including groups such as White British, Indian, Pakistani, Black African, and Caribbean communities. It also attracts a large number of foreign-born residents, contributing to its rich cultural and economic landscape. The UK has a highly educated workforce, especially in the 25 to 64 age group, and is a hub for international students and professionals. The third one is GDP performance and economic drivers. In terms of economic performance, the UK's GDP is about USD 3.1 trillion, making it one of the largest economies globally. Over 70% of its GDP comes from the service sector, which includes finance, healthcare, education, and creative industries. Despite recent economic challenges like Brexit and inflation, the UK remains resilient due to its diverse economy and strong institutions. Fourth point, which is the last one, why the UK is a relevant benchmark for Malaysia. There are three key reasons why Malaysia can look to the UK as a benchmark. First, we share a common legal and institutional heritage. Malaysia's legal system, civil service, and education structure are largely inherited from British rule, which make policy comparison and adaptation easier. Second, the UK has strong social safety nets, including healthcare, pensions, and unemployment benefits. And the third one, the UK is a global leader in education and skills development, which it serves as a model for TVET and higher education reform with best practices in research, digital learning, and industry collaboration.
In the book of rules, institutions, and processes that govern the relationship between employers, employees, and trade unions. The system covers areas such as collective bargaining, employment law, dispute resolutions, and workplace communications. Some of the key characteristics of the UK industrial relations system include: the first one is decentralizations, which means collective bargaining is typically conducted at the company or workplace level. And the second one is into individual rights. It is ensuring employees are protected and treated fairly. And the last characteristic is conciliations, where disputes can be resolved through dialogues rather than conflict. Next, let's look at the roles of the three main parties involved. The government is responsible for setting the legal framework, like Employment Right Act 1996, Trade Unions and Labor Relations Act 1992. It enforces laws on minimum wage, health and safety, and protects against unfair dismissal. The second one is employers. Employers are directly involved in negotiating with employees or trade unions. And the last one is employees. Employees have the right to join trade unions to protect their interests. They are also entitled to fair treatment and a safe working environment. For this lab, we will focus on the role of ACAS, which is Advisory, Conciliations, and Arbitration Service. The first one is advisory. Advisory provides guidance to employers and employees on best HR practices, workplace policies, and employment rights. Meanwhile, conciliations assist parties in resolving disputes before they escalate to legal actions. And in individual disputes, for example, like under unfair dismissal, early conciliation is a mandatory step before an employment tribunal can. And the last one is arbitration service. It offers a voluntary and binding resolution for disputes. And the hearing process is as follows, which is: the first one, we need to confirm the dispute the decisions needs to be made on. The second one is we need to allow all parties to explain their case and present any evidence. and discuss the case and answer questions related to the dispute. And the last step is each party is allowed to ask questions based on the evidence. I will explain the dispute resolution mechanism in UK's industrial relations system. Resolution is essential for settling workplace conflicts fairly and efficiently. There are four main types of dispute resolutions. The first one is ACAS conciliations and mediations. This involve mandatory early conciliations through ACAS for most dispute before a tribunal claim can be made. The second one is arbitrations. In this method, a neutral third party acts like a judge. Both sides present their case and evidence, and the arbitrator gives a binding decisions, and the parties can agree to negotiate almost any part of the process, making it flexible. And the third one is employment tribunals. This is a formal legal settings where employees can bring claims such as unfair dismissal or discriminations. And the last one is informal resolutions. Many disputes are solved internally within the workplace, and the common methods include direct communications, mediation, grievance, and performance reviews. This is often the fastest and most effective way to resolve issues.
Now moving on to UK employment laws and workforce policies. The UK's employment law is built on three pillars: statutory law passed by Parliament, common law based on court decisions, and EU laws retained after Brexit. Key legislation includes the Employment Rights Act and National Minimum Wage Act, both covering dismissal, redundancy, wages, and working time. The Equality Act strengthens protections against discrimination, while the working time regulations limit hours to protect health, and the Pensions Act requires employers to auto-enroll eligible workers in pension schemes. There are three main bodies that enforces these rules. ACAS supports dispute resolutions, employment tribunals settle legal employment issues, and HMRC manages tax and national insurance linked to employment. As for the minimum wage in the UK, the national living wage for workers aged 21 and above rose to £12.21 in April 2025, a 6.7% increase. Younger workers and apprentices also saw notable increases, with the rate going up by 18%. The average working week is capped at 48 hours per over 17 weeks, though employees can opt out. For people under 18, the limit is 40 hours per week and 8 hours per day. Legally, workers must get 11 hours of rest between shifts, a 20-minute break for shifts over 6 hours, and 1 day off each week. And we can see that most people in the UK work 31 to 45 hours weekly. UK workers average 1,867 hours a year, more than Germany but less than the US, Japan, and India. Finally, employees are entitled to 5.6 weeks of paid annual leave, which equals 28 days for full-time staff. In the UK, eligible mothers can take up to 52 weeks of maternity leave, split into 26 weeks of ordinary leave and 26 weeks of additional leave. Up to 39 weeks are paid, with the first 6 weeks at 90% of average earnings, and the remainder at £187 and 18 pence per week or 90%, whichever is lower. Shared parental leave allows up to 50 weeks off, with 37 weeks paid, shared between both parents under similar pay rules. The Equality Act 2010 protects against workplace discrimination covering age, gender, race, disability, religion, and pregnancy. However, the gender pay gap persists. In 2025, women earn 0.08% less than men on average, with the gap for full-time workers at 7.38%, showing a slight decrease. Termination and redundancy, employees in the UK with 2 or more years of service are protected from unfair dismissal. Employers must follow a fair process, though dismissals for health and safety concerns are automatically unfair. Redundancy pay applies after 2 years of service, with rates based on age: half a week's pay per year for under 22 years old, half 1 week for 22 and 40 years old, and 1.5 weeks for over 41 years old. There's no set retirement age in the UK. People can work as long as they like. However, the state pension age is currently 66, rising to 67 between 2026 and 2028. Children can work part-time from age 13 in areas like theatre or TV. Under 18s can't work more than 8 hours a day or 40 a week, and they are entitled to rest breaks. The Social Security and worker benefits. In 2025, employer NICs will rise from 13.8% to 15%. The threshold at which employers start paying NICs will drop from £9,100 to £5,000, affecting employee wages and benefits. By April 2025, 7.7 million people are expected to be on universal credit. The amount varies based on factors like standard allowance, housing, and childcare. For example, a single person under 25 gets £316 and 98 pence a month. For workplace pensions, employees must be automatically enrolled if they are 22 or older, earning over £10,000. Finally, statutory sick pay will increase to £118 and 75 pence a week starting in April 2025. Employees must be sick for at least 4 days and earn over £125 a week to qualify.
So now for labor statistic in the UK, there are about 26 million full-time and 9 million part-time workers, which makes it 34.1 million people employed in total. And from that numbers, 6.3 million of it are the foreign workers, which divided into two were the non-EU nationals, holding around 4.3 million jobs, which rise steadily after the introduction of post-Brexit immigration system in 2021. In contrast, EU nationals hold around 2.3 million jobs. And as for the top source countries of foreign workers, India lead the list with plus over 980,000 employees, followed by Poland at the second place with about 510,000 nationals. And the other three countries are Nigeria, Romania, and Pakistan, with its number of workers shown in the slide. And now we move on to employment sectors in the UK for both domestic and foreign workers. So here are the five sectors that is significant. And first, it is health and care, which employed about 3.7 million UK and 1.2 million foreign workers. Means they represent quite a significant part in the sector. Second, education were about 2.6 million UK and 357 million foreigner, where they filled about 12% of the roles. And both admin and support services and retail sector also relied heavily on foreign workers based on the numbers shown in the slide. And lastly, for agriculture sector, foreign workers slightly outnumber locals with about 189 million workers. In the UK, there are two main agencies that handling domestic worker regulations, which is UK Visas and Immigration, UKVI, and Home Office. So UKVI is a department under the Home Office that is responsible for immigration control like visa applications, manage employee sponsorships, and enforce immigration rules for foreign workers. Home Office, on the other hand, is the UK government department that sets policy on who can work, live, or study in the UK. So for entry policy, UK used a point-based immigration system for most foreign workers after the introduction of Brexit. So the applicants must fulfill all the requirements that will give them points, and in total they need 70 points to be able to apply for visa. And speaking of working permit types, there are four types, which is first is skilled worker visa. That is for people with a job offer in an eligible skilled role, and it requires sponsorship by a licensed UK employer. Next is health and care worker visa, which is designed for health and care professionals like nurses and senior care workers. Second last is temporary worker visa, which is for short-term jobs like farm work or hospitality. And last is global talent visa, which is for highly skilled individuals in areas like research, arts, and technology. And now for levy or employer responsibilities. First, sponsor license requirement. Employees in the UK must apply for a sponsor license from UKVI before they can hire foreign workers. Next, right to work checks. To confirm a worker is legally allowed to work in the UK, all employer must conduct a legal right to work checks before hiring them. Third, immigration skills charge (ISC), also known as the levy. So UK employees who are hiring under the skilled worker visa must pay the ISC, and the fee will help fund UK-based training and skills development. And lastly, sponsor duties, which is to keep accurate records of foreign workers, the report changes like resignation or job changes to UKVI. And next, for the domestic worker rights and protections, the agencies shown here are the ones that are taking care of the domestic workers' rights, such as right to national minimum wage, which is enforced by HM Revenue and Customs, legal working hours and time off, which supported by ACAS and Citizens Advice, return employment terms that supported by ACAS also, and lastly, protection from exploitation or abuse, where if there is a case, it will be investigated by Gang Masters and Labor Abuse Authority and UKVI.
Next part is trade unions and collective bargaining, starting with the role and legal foundations of trade unions. In the UK, trade unions represent workers in negotiating for better wages, working conditions, and employment rights. They also offer legal support in disputes like unfair dismissal or discrimination. Their rights are protected under several key laws, including the Trade Union and Labor Relations Act 1992, the Employment Rights Act 1996, and the Equality Act 2010. Unions may be recognized voluntarily or through a statutory process and are regulated by the certification officer. Moving on to membership trends, union membership is more common in the public sector and among older workers. Rates vary by gender in industry, with the private sector typically showing lower participation. Now let's focus on collective bargaining rights and structure. The process begins with the recognition of a union, either voluntarily or through a legal application to a central arbitration committee, which assesses employee support and bargaining unit suitability. Once recognized, unions negotiate employment matters like pay, working hours, and conditions. Outcomes are formalized in collective agreements, which may be legally binding or serve as guiding terms. If negotiations break down, conciliation through service like SCAS is available. Trade unions also hold the right to request relevant information such as pay structures or redundancy plans under TULRCA sections 181 to 185 to support effective bargaining. Additionally, employers are legally required to consult unions during key changes like mass redundancies, pension revisions, TUPE business transfers, and health and safety issues. Next is an overview of strike rights and the Trade Union Act. Strikes are legal under TULRCA if proper steps are followed, like holding a secret postal ballot with at least 7 days' notice. A 50% turnout is required, and for essential services, 40% of all eligible members must vote yes. Unions must also give 14 days' notice before the strike begins. The mandate lasts up to 9 months, and picketing must be supervised. Courts can stop unlawful strikes with injunctions. From June to December 2022, the UK lost 2.47 million working days to strikes, the highest since 1989, showing how impactful legal strikes can be. The Trade Union Act 2016 added stricter rules like opt-in requirements for political funds, mandatory reporting on finances and facility time, and also higher ballot thresholds for public sector strikes aiming to improve accountability.
I'll be presenting a brief comparison between Malaysia and the United Kingdom in terms of labor systems, focusing on similarities, differences, and what Malaysia can learn. Let's start with the similarities. When both Malaysia and the UK have structured labor laws, Malaysia with the Employment Act 1955 and the UK with the Employment Rights Act 1996. Each country also has active government agencies overseeing employment. In Malaysia, it's the Ministry of Human Resources, while in the UK, it's the Department for Business and Trade, supported by ACAS. In terms of legal protections, both countries ensure minimum wage policies, leave entitlements, and anti-discrimination laws. Moving on to the differences, the most notable one is union power. UK trade unions are strong, active, and influential in collective bargaining. In contrast, Malaysian unions are the most restricted and fragmented. When it comes to foreign workers, the UK uses a point-based system that mostly welcomes skilled workers with equal rights, while Malaysia relies heavily on low-skilled foreign labor under stricter and less protective conditions. Social protection is another major gap. The UK provides comprehensive coverage through pensions and unemployment benefits, whereas Malaysia mainly depends on the EPF, which focuses only on retirement savings. From this comparison, we can see a few key lessons. Malaysia could benefit from strengthening trade unions, providing better protection and rights for foreign workers, and expanding social protection schemes such as unemployment insurance. In conclusion, by adopting some of the UK's best practices like transparent industrial relations, inclusive labor laws, and broader social safety nets, Malaysia can build a more resilient and fair labor system for the future. Thank you.
So that's all from our group. Thank you.